Good day everyone, especially to you ma'am. I'm Criscia Autentico and today I'm going to discuss to you the chapter 13 of the Philippine Tourism Laws, which is the labor law. But before that, let me read to you this first. A motivated worker will be a productive worker. It is according to Abraham Maslow. And now let me introduce to you to our topic outline. First is the constitutional provision on labor. Second is the benefits, privileges, policies affecting employees. And lastly, we have the laws against discrimination. By the end of this chapter, our learning objective are enumerate the classification of employees, their benefits, privileges, and policies affecting them. Next is to identify some best practices in handling human resources in tourism establishments. Next is identify the procedures in handling sexual harassment in a workplace. And lastly, explain the rights of workers employed in tourism establishments. The tourism industry, with its labor-intensive nature, is prone to many labor issues. Hence, labor law plays a vital role in the efficient operation of the various business enterprises related to tourism. This chapter deals with important governing labor laws as well as the benefits, privileges, and policies affecting employees. And now for our first topic, which is the constitutional provisions on labor. Section 3, the state shall afford full protection to labor, local and overseas, organize and promote full employment and equality of employment opportunities for all. It shall guarantee that the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerned activities, including the rights to strike in accordance with law. They shall be entitled to security to ensure humane conditions of work and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. The state shall promote the principle of the shared responsibility between workers and employers and preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industry or industrial peace. The state shall regulate the relations between workers and employers, recognizing the rights of labor to its just share in the fruits of production and the right of enterprises to the reasonable returns of investments and to expansion and growth. In the section 14, this state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. In the section 15, the state shall respect the rule of independent people's organizations to enable the people to pursue and protect within the democratic framework their legitimate and collective interests and aspirations through peaceful and lawful means. In the section 16, the right of the Filipino and their organization to effectively and reasonably participate at all levels of social, political, economic decision-making shall not be abridged. The state shall, by law, facilitate the establishment of adequate consultation mechanism. Labor, whether local or overseas, organized or not organized, shall be given constitutional protection. The right to strike, although already a part of the right to self-organization, is specifically mentioned. The right to the living wage is expressly stated. A wage is a living wage if it is adequate to sustain a worker and his family in dignity. The state shall promote shared responsibility between workers and employers. Thus, the workers shall also participate in policy and decision-making processes affecting rights and benefits as may be provided by law. In this regard, the law may provide for consultations with worker or the unions. The union is the collective bargaining agent may be represented in the government or governing body of enterprise whose opinion voicing that of the union he represents may be taken into account by management. And the classification of employees. Employees of a company may be classified as follows. And the classification of employee of the company may be classified as follows. Regular employees. The employees who are deemed regular are those who have been engaged to perform activities which are usually necessary or desirable in the usual trade or business of the employer. And those casual employees who have rendered at least 1 year or of service, whether such service is continuous or broken, with respect to the activity in which they are employed. An employee who is followed to work after the probation period, and the worker is supplied by a labor-only contractor. The principal shall be considered regular employees of the latter. Next is the casual employees. Casual employees are those whose employment is neither regular, project, or seasonal. As determined under Article 280 of the Labor Code, there is casual employment where an employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer, and such job, work, or service is for the definite period made known for the employee at the time of engagement, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or not, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while activity exists. Next is the seasonal employees. Seasonal employees are those whose work or services is seasonal in nature and the employment is for the duration of the season. Regular seasonal employees are those called the work for the time to time. The nature of their work relationship with the employer is such that during off-season they are temporarily off, but during summer season they are reapplied or when their service may need it. Next is the project employees. A project employee is one whose employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or services to be performed is seasonal in nature and the employment is for the duration of the season. Next is the provision employees. A provision employee is one of who is a trial by an employer during which the employer determines whether or not he is qualified for permanent employment. Provisionary employment shall not exceed 6 months from that date the employee started working. In all cases of the provision employment, the employers shall make known to the employee the standards under which he will qualify as a regular employee at the time of his engagement. Next is the employees for a fixed term. These are employees covered in employment contracts providing for term employment or fixed period employment. Stipulation providing for the fixed period employment are valid when the period agreed upon has been knowingly and voluntarily agreed by the parties without force, duress, or improper pressure exerted on the employee, and when such stipulations were not designed to circumvent the laws on security or tenure. This is the overseas Filipino workers, also known as migrant workers. Overseas Filipino worker refers to a person who is to be engaged, or has been engaged on a remunerated activity in state of which he or she is not legal resident. A person to be engaged in a remunerated activity refers to an applicant worker who has been promised or assured employment overseas and acting on such promise or assurance substance damage and or injury. The law which governs overseas employment in Republic Act of 8042, or the Migrant Workers and Overseas Filipinos Act of 1995. And for the special workers, we have three types of apprentice. Apprentice, a worker who is covered by written apprenticeship agreement with an individual employer or any of the recognition entities. It is a person undergoing training for the approved apprenticeable occupation during an establishment period assured by an apprenticeship agreement. Second is the learners. Learners are the personnel hired as trainers or trainees, semi-skilled and other industrial occupations which are non-apprenticable and which may be learned through practical training on the job in a relative short period of time which shall not exceed 3 months. And next is the handicapped workers. Handicapped workers are those who earning capacity is impaired by age or physical or mental deficiency or injury under Section 4A for RA 7277, also known as the Magna Carta for Disabled Person. Disabled persons are those of suffering from restriction of or lack or different abilities as a result of mental, physical, or sensory impairment to perform an activity in the manner or within the range of considered normal for a human being. Now let's proceed to our next topic, which is the benefits, privileges, policies affecting employees. We have the minimum wage. By the virtue of a Public Act number 6727, Wage Regionalization Act, the determination of minimum wage rates are now within the function of the regional, tripartite, and productivity board. The concept of minimum wage means more than setting or a floor wage to upgrade existing wages. Minimum wages underlies the effort of the state to promote productivity improvement and gain-sharing measures to ensure a decent standard of living for the workers and family to affirm labor as a primary social economic force. Next is the collective bargaining. This means conferring promptly and in good faith for negotiation agreements with respect to wage, hours of work, and etc., including in the written contracts called collective bargaining agreement or CBA, adjustments or grievance, etc. The provision commonly found in a collective bargaining agreement are enumeration or reservation of management rights. Second is union recognition and security. Third is wage and fringe benefits and their administration. Fourth is physical working conditions. Fifth is elected personnel management and plant operation practices. And sixth is grievance and arbitration. And lastly is the duration of contract. The Labor Management Council. Under Article 255 of the Labor Code, it serves the right of an individual employee or group employee or an ionized or non-ionized to present grievance to their employer at any time, with or without collective bargaining, with or without exclusive bargaining representatives. The Department of Labor and Employment promotes the formation of Labor Management Council or LMC. Is organized in organized establishments. An LMC, either as council or committee, can serve as a forum where management and employee may air their concerns short or collective bargaining. And now let's proceed to the maternity and paternity leaves. Maternity leave benefits are covered under Republic Act of Number 8282, May 1, 1997, also known as the Social Security Act of 1997. Under said law, a female member need not to be married who has paid at least 3 months contributors or contributions in the 12-month period immediately preceding the semester of the childbirth or miscarriage shall be paid a daily maternity benefit equivalent to 100% of her average daily salary, credit for 60 days or 78 days in case of cesarean delivery. On the other hand, Republic Act Number 8187, also known as the Paternity Leave Act of 1996, governs the guaranteeing of paternity leave benefit to every married male employee. Under the said law, every married male employee is the private and public sector shall entitled to paternity leave of 7 days with full pay for the first 4 deliveries of the legitimate spouse with whom he is cohabiting. The following conditions proceed to the union rights, strike, and lockouts. A legitimate labor organization or LLO has the requisite personality to sue on behalf of its member for their individual money or claims. For the purpose of collective bargaining, a legitimate labor union must be certified as a exclusive bargaining agent who won in a certification election. Strike means temporarily stop or of work by the concerted action of employees as a result of labor or industrial dispute. Lockout means temporary refusal of an employer to furnish work as a result of industrial or labor dispute. The service charges. The rule of service charges applies only to establishments collecting service charges such as hotels, restaurants, lodging houses, nightclubs, cocktail lodge, massage clinics, bars, casinos, gambling houses, and similar enterprises, including those entitled operating primarily or private subsidiaries of the government. And next is the employment contract. An employment contract is that by virtue of which one person binds himself with respect to another employer to place at their service at the latter his own effort in work, and the latter in turn agrees to pay him a compensation proportional to the time to the quality of work done. Next is the death benefits. Under the Social Security law, upon the death of the member who has paid at least 36 monthly contribution prior to the semester of death, his primary beneficiary shall be entitled to the monthly pension, provided that if he has no primary beneficiaries, his secondary beneficiary shall be entitled to lump sum benefit equivalent to 36 times the monthly pension. If he has not paid the required 36 months contribution, his primary and secondary beneficiaries shall be entitled to lump sum equivalent to the monthly pension times the number of the monthly contribution paid to the SS, or 12 times the monthly pension, whichever is higher. Next is the health benefit. This includes sickness, medical, and hospitalization benefit under the Social Security law. A member who has paid at least 3 months contribution in the 12-month period immediately preceding the semester of sickness or injury and is confined more than 3 days in the hospital or elsewhere is approval of the SS shall be paid a daily sickness benefit equivalent to 90% of his average daily salary credit. Next is the drug testing under the Public Act number 9165 June 7, 2002, also known as the Comprehensive Dangerous Drug Act 2002. Drug testing shall be done by any government forensic laboratories or by any of the drug testing laboratories accredited and monitored by the Department of Health to safeguard the quality of the test results. Drug test certificate issued by accredited drug testing centers shall be valid for 1 year period from the date of the issue, which may be used for other purposes. And for retirement, under Article 287, the Labor Code as amended by Public Act number 7641, also known as the New Retirement Law, any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employee contract. In the absence of the retirement plan or the agreement proceeding for retirement benefits of employee, establishments, or employee upon reaching the 60 years or more, but not beyond 65. Next is SSS, PhilHealth, Employees Compensation Commission, and Pag-ibig. Employees in the private sector are covered under the SS law, wherein the mission is to promote the unperfect, a sound, and viable tax-exempt social security system suitable to the needs of the people, which shall provide meaningful protection to the member and their beneficiaries against hazard or disability, sickness, maternity or old age, death, and other contingencies resulting in the loss of income or financial burden. PhilHealth assumed the responsibility of administering the former Medicare program for private sector employees with its landmark transfer from the Social Security system under April 1998. With this transfer came the turnover of the health insurance funds, initially totaled 14 billion pesos from the SS. The amount covers employee and employer's shares is the medical care program. And lastly is the termination of employment. It is the constitutional rights of worker security or tenure and their right to be protected against dismissal, exemption, just to unauthorized cause and without prejudice of the requirements to notice Article 283 of the Labor Code, due process in termination disputes in the heart of security of tenure and is personal to the employee. And now let's proceed to our next topic, which is the laws against discrimination. Article 3, Declaration of Basic Policy. The state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employees. The laws against discrimination with respect to the labor are the follows. Republic Act Number 7277, also known as the Magna Carta of Disabled Person. The following Constitution acts of discrimination of the handicapped workers. A is limiting, segregating, or classifying a disabled job applicant in such a manner that adversely affect his work opportunity. Using qualification standards, employment tests of other selective criteria that screen out in tens of screen out disabled person unless such standards, tests, or other selection criteria are shown to be job related, but the position in question and are consistent with the business necessity. Utilizing standards, criteria, or methods of administration that have the effect of discrimination on the basis of disability or perpetuate the discrimination of the others who are subject to common administrative control. Providing less compensation such as salary, wage, or other forms of remuneration and fringe benefits to the qualified disabled employee, and favor it for the non-disabled employee over a qualified disabled employee with respect to the promotion, training, opportunity study, and scholarship grants, and reassigning for transferring a disabled employee to job or position he cannot perform. We have the employment for women. It is a policy of state to protect the working women by providing safe and healthful working conditions, taking into account their maternal function, and provide such facility and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. Next is the sexual harassment of the workplace. Under Republic Act of Number 7877, also known as the Sexual Harassment Act of 1995, sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employee, manager, supervisor, and agent of the employer, or any other person who have authority, influence, or moral ascendancy over another in the work environment, demands, requests, or otherwise requires any sexual favor from others, regardless or whether the demand, request, for requirement for submission is accepted or not. Next is the best labor practices in tourism establishments. This topic has been added to enable the readers to appreciate the best labor practices at selective tourism establishments from the lodging industry, travel agency and tour operations, transportation companies, food service industry, and tourist sites. It will be noted that 90% of the selective respondents agree that the imperative to the proactive and supportive humanities or human resource department which will be instrumental in enhancing the welfare of the employees and helping the company towards growth in investment. An open door policy with the president or general manager of the company is most welcome, as it has proven to be the most effective means of removing the barriers of communication and enhancing shared responsibility of the nationhood between capital and labor. And that's it for my report. Again, I'm Criscia, Autentico, and thank you for listening, and I hope you learned something. Good day!